Can a landlord change the locks without notice on a commercial property? Commercial property is governed by the terms of a commercial lease. These tend to be quite different from residential leases. With it comes the rights and obligations of both the landlord and tenant. In general, the law is less forgiving if a commercial tenant has breached the terms of the lease. This is in contrast to a residential tenant where making people homeless is something the courts seemingly try and avoid at all costs. Hi, I'm Felix from Blackstone Solicitors, and in this video I'm going to discuss whether a landlord can change the locks on a commercial property. Okay, so can a tenant be evicted before the end of the lease? The process of evicting commercial tenants early is known as forfeiture of the lease. This can only happen if the lease contains a forfeiture clause. As a tenant, it is important you understand the rules governing eviction, as it can have a profound effect upon your business. How does a landlord go about forfeiture? The most common breach of a commercial lease is non-payment of rent. However, it is also common to find lease terms that allow for forfeiture for other reasons. These can include using the property for illegal purposes, any form of insolvency, abandonment by the tenant, or any other breaches of the lease. There are two fundamental methods of the landlord exercising forfeiture: by court order or by what is known as peaceable re-entry. This is where the landlord can ultimately change the locks. Court proceedings. Once the tenant has been served possession proceedings by the landlord, this is regarded as unequivocal election by the landlord to forfeit the lease. Upon the service of an issued claim form, notional physical re-entry occurs. The act of the landlord must be unequivocal and has the effect of forfeiting the tenancy, in the same way a peaceable re-entry does. The lease would then be considered to be forfeited and is brought to an end. Once the lease is forfeited, the landlord is still entitled to claim back any rent that has not been paid. In other words, evicting commercial tenants from premises does not relieve the tenant from having to pay back any rent arrears. The safest way when it comes to evicting a commercial tenant is by commencing a possession claim in the county court. This process, however, can often be a quite lengthy process. So, can a landlord change the locks? The powers of a commercial landlord to deal with non-payment of rent are far-reaching. By means of forfeiture, virtually all commercial leases will have a clause allowing the landlord to terminate the lease if the rent is unpaid for a specified number of days. This is normally somewhere between 14 to 28 days. Provided that any required notice has been served and the prescribed time frame for the tenant to remedy the breach of lease has lapsed without adequate action, the landlord can then seek to re-enter the property. In fact, no notice is required in respect of rent arrears, only other breaches. For peaceable re-entry to be satisfied, the following points must be considered by the landlord. In order to avoid confrontation, the landlord would need to ensure the premises don't have anyone in physical occupation at the time. If there is any risk of violence whatsoever, the landlord runs the risk of committing an offence under Section 6 of the Criminal Law Act 1977. If the landlord can demonstrate peaceable entry, he or she can change the locks. The changing of the locks is to be considered by the tenant that the landlord has terminated the tenancy agreement. A notice must be left by the landlord that is clearly visible to the tenant, detailing the actions taken. Is there anything a tenant can do about forfeiture? You may be able to apply for relief from forfeiture. This will allow you the option to remedy any breaches of the lease, including repayment of all rent arrears and costs, including bailiffs and/or locksmiths' fees, if the landlord has exercised peaceable re-entry. If this has been done, being evicted is no longer a viable option for the landlord. Once a possession order is granted, the tenant will usually have 28 days to either apply for relief by, for example, paying any rent arrears and your legal fees, or, if they are unable or unwilling to meet the relief conditions imposed by the court, vacate the premises. At this point, the landlord will have full possession of the property. If you need legal help with commercial leases, contact us at Blackstone Solicitors Limited. We have offices in Manchester and Central London and have clients across the country. If you found this video helpful, like it, share it and tell other people about it. Press the subscribe button below to keep informed about our latest videos. Goodbye and thanks for watching.